Both the teams, you have only two members, or you have a researcher as well?
Two members.
Okay.
Just two, sir.
Okay. So we'll begin the session in 5 minutes. One of the judges is just joining. Meanwhile, you may let me know how much time each speaker would be taking.
So I'll be taking 12 minutes, and my co-counsel will take 30 minutes, and we'll keep the last 5 minutes for the rebuttals.
Sir, you're muted.
Speaker 1 would be taking 13 minutes, and speaker 2 would be taking 12 minutes. Correct?
No, sir. Speaker one will be taking 12 minutes. Second speaker will take 13 minutes, and the last 5 minutes for rebuttals.
Okay, thank you.
Thank you, sir.
And sir, here I will be taking 15 minutes and speaker one will be taking 10 minutes.
So also, here's a request. Can you please keep informing us about the time ending?
Yes, please you keep your text box on, so I'll just keep informing.
Thank you.
Good morning, everyone. Have both the judges joined the session? Am I audible?
Yes, sir.
Can the judges hear me? Deepak sir, am I audible to you? Am I audible to everyone?
Yes, you are audible.
Good morning to everyone. So, we'll begin the session. I'll shortly introduce both of our judges. We have with us Miss Sunita Ojaji. Ma'am is an advocate on record in the Supreme Court. Ma'am basically practiced before the Supreme Court as well as before the High Court and other tribunals. Ma'am graduated from the Campus Law Center, Delhi University in the year 2013. Then my my lord has been representing SDMC as additional standing counsel. Ma'am has also been representing Union of India as senior panel counsel. Ma'am has other numerous panels. So we welcome you, ma'am, to the session. We also have with us Mr. Deepak Kumarji. Sir has been practicing law from about 20 years. Sir has handled many criminal cases. Sir has also defended many famous criminal cases such as the stump paper scam. So we welcome you, sir, to the session. And I also welcome all the participants and I wish all the best to the participants. So before we begin the session, I'll give a brief brief rules of the session. I hope the participants have the detailed rule book. Yes. So I'll give the brief rules. Each team will have a maximum of 30 minutes to present their oral submissions, including time for rebuttal. Maximum 5 minutes can be reserved for the rebuttal, which can only be reserved for any one speaker. Teams are requested to notify the division of time between the two speakers as well as time for rebuttal at the beginning. No speaker will be permitted to address the court for more than 20 minutes. Teams will be intimated on every 20 and 30 minutes. Judges, at their discretion, may extend oral argument time up to a maximum of 10 minutes per speaker. Teams will strictly maintain anonymity during the complete session and also while referencing to any case laws using present now option. At the time when one participant is speaking, others are expected to keep their microphones on mute. So the teams have already told me the time that would be taken by each speaker. So which team is for the prosecution? 5:30. Okay, team 5:30. Could you please tell me again the time that would be taken by each speaker?
So the timing that the speaker will take.
Yes, yes.
Okay, so I'm the speaker one, and I'll take 12 minutes, and my co-counsel will take 13 minutes. Yes, sir.
And 5 minutes for rebuttal. Okay.
Yes, sir.
So you may start with the session.
Thank you, sir. So, warm greetings, Your Lordship. May it please the court, I'm the counsel on behalf of the state, that is the petition side. With the court's permission, I would like to reserve my last 5 minutes for the rebuttals. Your Honor, the present case is against the five accused persons, well known as Samir, Monu, Kalumama, Peter, and Sohail, as they have acted in violation of the Indian Penal Code 1860 and the Unlawful Activity Prevention Act 1997. Your Lordship, now I'd like to ask the Honorable Bench if they are interested to know the facts, brief of the facts of the present case, or if they are well versed. May I have your permission to proceed? Am I audible, sir? Your Honors, on 24th of...
You can proceed.
Okay, sir. Okay, thank you, Lordship. Your Honors, on the 24th of February 2026 at 9 in the morning, some secret information was provided to the Special Cell of Delhi Police that two suspects will be carrying the FICMs on 25th of February 2015 by the train going from Malda town to Delhi. Then, on the very next day, as per the information received by the police, the train was raided. That is the general coach number 2 of Faraka Express, train number 13413, on its arrival at platform number 5 of Old Delhi railway station on 25th of February. During the raid, the high-quality fake Indian currency notes of total face value rupees 10 lakh was recovered from the accused persons, namely Samir and Monu. And after the recovery of all the other things that they were in their possession, the accused persons were arrested, Your Honourship. Your Lordship, the further discussion is constructed on the provided facts. So if the facts are clear, the Council seeks permission to proceed with the arguments advanced. Thank you, Your Lordship. Your Lordship, the Latin maxim, actus non facit reum nisi mensit rea. It tells us that for any act to be illegal in nature, it must be done with a guilty mind. This maxim can find its importance under the Section 14 of the Indian Evidence Act 1872, which states that facts which indicate state of mind or intention are relevant in issue. Your Honor, the criminal intent of the accused is very much clear from the aggression which they have shown while delivering their speeches to instigate the people to wage war against the government. Especially the remarks which the accused person have made, that is दुल्हन को सजाना पड़ेगा और दुल्हन को सजाने का वक्त आ गया है, cannot be ignored at all. In the case of Captain Abdul Sattar versus R.H. Mendelssohn, it was stated that the intention behind the act is to be understood. One cannot hide under the blanket of benefit of doubt in such type of serious offences, Your Honourship. I would like you to refer to page number 23, last paragraph, in which I have mentioned one case law. In the case of CBI Hyderabad versus Narayan Rao, it was held by the court that agreement to do an act is the essence of criminal conspiracy. Direct evidence is rarely available, so it has to be proved on the basis of circumstances. And in the present case, the circumstances clearly shows the malified intention of the accused persons, Your Lordship. First of all, some people of the accused association were ignorantly talking about the transfer of FICNs at Guddu's pawn shop. When Guddu Singh received this information, he immediately went to the police station. Then on the very next day, as per the information received, the police actually raided the train and the accused persons were there with the FICNs. Secondly, Your Lordship, the remarks made by the accused to instigate the people are so horrendous that it will do nothing for the people's welfare. In fact, they will exploit their lives, which they already have. Your Honor, here I'd like to mention that our Indian Constitution itself does not make any right an absolute one. It puts restrictions even on the fundamental right. Likely, there are so many restrictions on Article 19, which the defense would be taking the help of Article 19, that is fundamental of right of speech and expression. But and also, as I've told you, that reasonable restrictions can be there. But in the present case, the organization that we are talking about is exercising this fundamental right without any limitation and leading the incitement of an offense. Thirdly, the fact that they all agreed to be a part of an association even after it was declared to be unlawful, as it went against the sanctions imposed by the government of India, which is the lawmaker gives us reason to believe, as per Section 26 of the Indian Penal Code, that all had prior meeting of minds were aiming towards the common objective of going against the law. Fourthly, Your Lordship, the technical evidences found in the form of call, detailed analysis, the tower location of the mobiles, and the transcript on the important dates, along with the confessions made by them, which also discloses such dates as a matter of fact, which is of utmost importance, Your Lordship. Your Honor, though Section 26 of the Indian Evidence Act and Article 20 of the Indian Constitution protects one's right against self-incrimination. But Your Lordship, it is held in so many cases that the confessional statements can be admissible if they are corroborated with the circumstantial evidences. Your Honor, here I'd like you to refer to page number 12 that the defense have submitted in their submissions, in which the last lines of their written submission itself says that because during the investigation, the respondents gave all the information they had about the plan and never hide anything. Your Honor, here I'd like to ask the defense counsel that what does the word plan specify here, Your Honor. Therefore, it is humbly stated in this court that mens rea, that is the criminal intention, was always there in the accused persons throughout they started their activities, that is while delivering their speeches carrying the bags of FICNs, also depicted which is also depicted through their call records. Henceforth, the alleged sections against the accused persons are completely appropriate, and the accused persons must be convicted accordingly, Your Honorship. Moving forward, Your Lordship, I'd like to state the maxim ignorantia facti excusat, ignorantia juris non excusat. It is a Latin maxim which means that ignorance of fact is an excuse, but ignorance of law is no excuse. Your Lordship, Samir and Monu were found with two bags filled with FICNs, which they haven't disclosed as of why they were carrying it. Just mere denial of the reason or refusing to state a valid excuse for carrying possessions counterfeit does not save the accused person from the charge against Section 489B and C of the Indian Penal Code 1860, ownership. Since the accused persons were running an organization, so an excuse on their part that they were completely ignorant of the fact as if they were carrying the FICNs should not be admissible at all, sir. Therefore, for the security of the nation, these facts must be considered with great caution and awareness. Lastly, it is humbly submitted that the accused person should be held liable for commission of offences under Section 120B, which talks about punishment of criminal conspiracy, Section 489B, and Section 489C, which talks about the use and possession of forged or counterfeit currency notes or banknotes, Section 121, which talks about the waging of war or attempting to wage war against the government of India. Section 123 for concealing with intent to facilitate design to wage war. Section 201 for causing disappearance of evidence of IPC 1860. And Section 16, 17, 18, and 20 of the Unlawful Activities Prevention Act 1997. Your Honor, now I'd like my co-counsel to take the proceedings forward. Any questions, Your Honor?
I don't have any question. My learned brother may want to ask something. Deepak ji, would you like to ask some question? Deepak ji, you are not audible.
Sir, your mic is muted.
Am I audible? Madam, confession is not admissible in law, in evidence. So how you can say that the confession is a reliable document to convict the accused?
I apologize, sir, you're not audible clearly.
I say confession is not admissible in law, in evidence.
Yes, sir. Yes, sir.
How you can say the confession is sufficient to convict the accused?
Yes, sir.
A recent judgment, State versus Shubhamrit Kaur versus State of Tamil Nadu.
So what I'm trying to say here is that though Section 26 of the Indian Evidence Act itself says that the confessions made by the accused during the investigation in front of the police custody are not admissible. But sir, it has also been stated in so many cases that the confessions can be admissible if they're corroborated with the circumstantial evidences. And sir, in the present case, we are having enough evidences which itself shows that means there are so many circumstances which, if in corroboration with the confessions made by the accused, can be held to be admissible. And moreover, sir, as I've said earlier as well, that the defense counsel, that is from the accused side, they itself on in their written submissions on page number 12, last lines itself, they had stated that because during the investigation, the respondents gave all the information they had about the plan and never hide anything from the police. So, sir, word plan that they have used in their written submission, to the defense counsel that what does the word plan specify here, sir? What does it mean? Any other questions, Your Lordship?
No.
Thank you, Your Lordship. Over to you, Ms. Counsel.
My sincere greetings to the honorable bench. Without any further ado, I'd like to move forward with the arguments if the court grants permission. Thank you, Your Honors. So, Your Honor, the defendant has been violative of Section 16, 17, 18, and 20 of UAPA, that is Unlawful Activities Protection Act, which prosecution will prove to the chain of facts developed and collected by police and NIA during investigation and inquiry further. Raid as per the information received by Special Cell. Then, on search, FICN was recovered from Samir, accused 1, and Monu, accused 2, both rupees 10 lakh. Confessions by them that they had procured FICN, that is fake Indian currency note, from Kaluma. CFSL submitted their report regarding FICN of them being fake and high quality. Later, as per confession, Peter was to collect the FICN who would have delivered it in Pulwama and JNK, that is Jammu and Kashmir. Further confession says that they used to receive consignments of FICN from Kalichak Malda and travel in general coach. They were arrested, Your Honors, from Malda with the bag of FICNs while traveling in general coach. As we've said earlier, that even though Section 25 of Indian Evidence Act states that admissibility of any confessions made in police custody is not admissible in the court, but corroborative evidence, when found, can be found admissible on the ground, that thus the landmark story, and the ground story states that the facts were corroborated with the confessions made by the accused, hence admissible. Now, if the money used and was for the rallies to raise their voice against the oppressed class, as per the miscreants, that is Samir, Monu, Kalu Mama, and the witness statements later found by defense, what rally related to West Bengal's oppressed class is being conducted in Pulwama? Is there even a connection between the two? Further admission lays down that Kalu Mama used to take instructions from Sahel, who was planning to carry out bomb blasts in Pulwama on Indian Army convoy by 15th August, and that they were in touch with Lashkar-e-Taiba, a very well-known terrorist group, as we all know. Defense will take protection of Section 25 of Indian Evidence Act, but again, admissibility of facts arising out of realistic circumstances which can be foreseen are admissible, and as per the very own statement of accused, as the witnesses' statements have been submitted by defense, I'm sure, the very own statement of accused Kalu Mama says that the association started receiving funds from across the country, from Pakistan and Bangladesh, for their upliftment and sensitization programs. Why would the countries involved with our nation worry about the upliftment of anonymous group as this, talking about oppressed class of West Bengals, if they don't have any hidden agenda, Your Honors? Thus, proving their link with the countries considered and who have in the past, with references to a lot of cases of terrorist acts, have submitted their links with the countries where war are. The statement stated by Suhail, Dulhan ki vidai ka waqt badalna padega, or Dulhan ki vidai ka waqt badalna hai, when sometimes someone says when sanctions were imposed by the government are nonetheless some left-wing extremism remarks laid down by Suhail, they're one of the active members of the association. Supplementary support to statement and adding more innuendo to the statement again said by them says Dulhan ki vidai ko sajane ka waqt aa gaya hai, as the blast word. And now, considering the paradigm and pattern set by them was disrupted by Peter committing suicide right after the arrest of Monu and Samir, and what is the reason of Suhail absconding if he's an innocent? It's the lack of confidence, Your Honor, in the government and judiciary and the agony against their own nation which has brought them here. The defense should not take shadow under the lack of corroboration from prosecution side and prove their own case. It is protection of the fundamental rights of accused of right to privacy and the right to life that their telephonic conversation and personal correspondence could not be tested, Your Honor. But it is sufficient to develop the continuous link between them all. Further, stating the punishment for Section 16, that is punishment for terrorist act. The UAPA includes any act that is likely to threaten or likely to strike terror in people, giving unbridled power to the government. But here, understanding that nation security is at threat, it is not but millions of lives at stake, which is why government has granted the unbridled power and thus should be given the benefit of doubt in the present case. Your Honor, if you refer to the page 27 of our submissions, there's a case being provided in unequal SK versus National Investigation Agency. It was stated that even when direct evidence is not found, circumstances are circumstances are enough to well verse the state with the working of a situation under which accused should be held liable. UAPA is imposed when there is threat to the security of nation. The allegations made are where accused persons were planning a bomb blast against their own country, whereas the problem stated by them was with government policies, which clearly shows how they violated the sacramental fundamental rights. The defense will take protection under the right that they had right to protest under Article 19 to raise their voice by right to speech and expression. Which rioting is against the public tranquility, whereas joining an insurrection against the government of India is also a forming part of war. Thus, they should be convicted of waging war against their own nation, Your Honors. We live in a democratic country, but we cannot surpass our rights on stake of human lives. Fundamental rights also come with reasonable restrictions as provided. And so were the sanctions imposed by the government on them, which they took in a very weird way. And thus Sohail made a remark that was horrendous and filled with innuendo, that is, Dulhan ki vidai ka waqt badalna padega. UAPA allows for searches, seizures, and arrests based on personal knowledge of police officers without any written validations from superior judicial authority. The statement thus justifies the action taken by police in the best interest of public when the information was received by them from Guddu Singh, giving the credibility of the information received. Section 17 states punishment for raising funds for terrorist act, which has been proven by the admissibility of facts from the statement made by Kallu Mama when they said that they started receiving funds from all across the country of just Pakistan and Bangladesh, who are at war with our own country and have in the past made such acts which has been terrorist acts and have been submitted and have thus been considered in an agony of our country. Benefit of doubt should be given to the prosecutors here, Your Honors, as there is lack of physical evidence of any activity prior to arrest. But defendants cannot form the argument on basis of our weakness, because in the case of UAPA, I want special attention of judges in the present in the statement I'm about to say, that in the case of UAPA, the onus to prove the argument is on the one who is charged guilty of it, which is Sameer and others in the present case, and not the one who affirms. Government sanctions outraged Sohail and group as per the witnesses Iqbal Khan, and even after being declared unlawful by the government, they did not stop their so-called peaceful protesting. We've all heard of Naxals. This outrage by them is nonetheless Naxal policies for their own benefit that put sovereignty and security of India at stake, Your Honors. Further, Section 18 states punishment for conspiracy, etc. A criminal conspiracy exists when two or more people agree to commit almost any unlawful act, then take some action towards its completion. Action taken need not itself be a crime, but it must indicate that those involved in conspiracy knew of the plan, intended to break the law, therefore. A person may be convicted of conspiracy even if actual crime was never committed, as it was prevented by the police, Your Honors. Their plan was abrupted by the raid and search and further investigations made, ergo putting Sameer and Monu therefore on radar. It was mentioned in Muthuswamy versus State 1952, which is mentioned on page number 25, Your Honors, that there is no rule of law which says that conviction can't be based upon uncorroborated confessions. However, as a matter of prudence, it is usually considered safe to look at confessions in the light of all the evidence on record, which has been proved as the circumstances has been proved and the facts and the chain of facts thus developed and established by the prosecutors proved, therefore. All the statements mentioned above conclude to verification of inquiry. Innocent until proven guilty does not apply when life of whole nation is at stake, not to mention court can assume the damage if the blast had been successful. Section 20 states punishment for being member of terrorist gang or organization. On basis of FICN found with Monu and Sameer, which happens to appear as self-incriminating documents, depicts that they were active member of the groups. They were sent by Kallu Mama for delivery of FICN. Active participation by these two and delegated orders thus takes us to believe in the chain of evidences found all along. Extraordinary circumstances and instances arising out of chain of evidence is impeccable in considering them as active member in conspiring against their own country, Your Honors. Under Section 34 of IPC, when a criminal act is done by several persons in furtherance of the common intention of all, each of such person is liable for that act in the same manner as if it were done by him alone. Thus proves our case. Your Honor, submitting, therefore, in the light of issues raised, arguments advanced, and authorities cited, may this honorable court be pleased to convict the offenders for their misdemeanor under the charges as mentioned above, and in or pass any other order it may deem fit in the interest of justice, equity, and good conscience. Thank you, Your Honors. Any questions?
Learned Counsel, you have taken us through law and judgments. Can you, in 1 minute, summarize what are your impeccable evidences in favor of the prosecution?
Thank you, Your Honor. Your Honor, the chain of evidences that's established by me and not the proper provisions of the section stated was the main reason that there was no as such physical evidence present in the case because the act did not take place. It was prevented way before. But the planning of the such act, the terrorist act, was found and was proved by the chain of evidences and circumstances created by the accused persons and thus proved by NIA and the Special Cell of Police. Your Honor, what I'm trying to say is that
my question, sorry to interrupt, my question was a little different. What are the main evidences that the prosecution is relying upon? If you could, would you like
Your
to
Honor,
summarize that?
Yes, Your Honor. Yes, Your Honor. As per their very own statements, the witnesses' statements, Your Honor, they were part of association which was working against the oppressed class. Whereas when they started receiving funds, government imposed sanctions on them, and their organization was considered unlawful. It was then and there when they had to stop sensitizing programs and breaching the law and sanctions imposed by government on them. But they did not take it in the right way and thus planned a bomb blast on the Army of India, putting the sovereignty and security of our nation at stake, is what we're trying to express here. Confessions, the technical evidence, the extremist remarks, and founding of FICN from the same track, as per the confessions made in the police custody, proves all our circumstantial evidence, and there's my case, Your Honor. If that justifies your question, Your Honor.
May I request the court pastor now to take over? Unless my brother has some queries. Deepak ji?
Somehow my network. So, is the first team finished with their arguments? Team 550, have you addressed the arguments? Then team 544, you may start with your arguments.
May it please the Honorable Court, this is the counsel appearing on behalf of the accused on the instant case of State NIA versus Sameer and others. Before I make my submissions, I wanted to ask if the Lords are sufficiently familiar with the facts of the present reclaiming motion.
We are familiar with the fact. Unless you would like to highlight any specific fact which is in the interest of your client, please feel free to do so.
No, Your Honor. So I will be moving on with the issues first. So firstly, I'm going to submit that the accused parties are not guilty under criminal conspiracy, attempting to wage war against the government of India and concealment of the existence of evidence to facilitate the same. Then my learned co-counsel would submit that the accused are not guilty of possessing and using forced counterfeit currencies, destroying evidences, and partaking in any terrorist activities which are punishable under Section 16, 17, 18, and 20 of the UAPA Act 1967. Now, moving forward, the first issue is whether my clients are guilty of criminal conspiracy or not, which is punishable under Section 120B of the Indian Penal Code 1860. Section 120B seeks to punish criminal conspiracy, which is defined in Section 120A as when two or more persons agrees to do or cause to be done an illegal act, or an act which is not illegal but by illegal means, such an agreement is designated as criminal conspiracy. Now, as per the judgments of many previous cases like Shantilal Mehta versus CBI or Baldev Singh versus State of Punjab, one of the most essential elements of any criminal conspiracy is that there should be meeting of mind between the two parties to pursue a criminal objective. And there should be a criminal objective. However, in the present case, my clients did not even know what was inside the bag they were holding. There was no meeting of mind. They had no knowledge of what they were holding, nor was there any criminal objective because they were just members of union who were working for the betterment of the society. Now, moving forward with the next issue, I am going to submit that my clients are not guilty as charged under Section 121 of the IPC. Section 121 seeks to punish anyone guilty of waging war against the government of India. It states that whoever wages war against the government of India or attempts to wage war or abates of waging such war shall be punished with death or imprisonment. In the landmark judgment of State versus Navjot Sandhu, the Supreme Court stated that the true criterion is quo animo did the gathering assemble, that is, with what intention did the gathering assemble. The intention and the purpose of the warlike operations directed against the government machinery is an important criterion. Every insurrection against the government of India does not amount to waging of war as per Prevention of Terrorist Act 2002, uh, Section 3.1. Terrorist acts are done with intent to threaten unity, integrity, and security or sovereignty of India, or to strike terror in people or any section of the people by using bombs, dynamite, or other explosive substances. In present case, my clients Samir and Monu joined the organization created by Sohail because they felt that the government was not working well enough for the upliftment of the poor class. They just exercised their freedom of expression. They did not want to attack India or threaten its unity. All they wanted was to get the attention of the government who was not working well enough for the betterment of society and was trying to divide people uh, based on caste and religion. All the My clients were ordinary people who wanted to work for the improvement of society as they were running skill training camps in various parts of the countries to assist the people for the same reason. They had no intention of going on war against the government of India. Now, moving forward with this next issue is whether my clients are guilty of Section 123. It is humbly submitted before this honorable court that the clients are not guilty of concealing the existence of any design to wage war, which is what Section 123 seeks to punish. According to the statement of NIA, Kallu Mama went to Sohail's house and destroyed all the evidence. But according to NIA's statement also, Kallu Mama was arrested from Malda, West Bengal. Then how did he ever get the opportunity to run to Sohail's house in Pulwama and destroy all the evidence? This clearly indicates that the police are lying about the confessions made by our client, and other thing cops are also lying about is uh, statements made by all our client. The statements on the charge sheet were never made by our clients. This is definitely an attempt by the authorities to portray a few ordinary citizens who were simply dissatisfied with the administration and are exercising their right to free expression as terrorists. It's the authorities attempt to frame these poor people who are discontent with the government for very legitimate reasons as deadly terrorists. In any case, according to Section 25 of the Indian Evidence Act, no confessions made to a police officer shall be proved as against a person accused of any offence. Also, according to Article 23 of the Indian Constitution, no person accused of any offence shall be compelled to be witness against himself. As a result, we will contest the veracity of any comment which was allegedly made by our clients during the police investigation. Thank you. Now my learned counsel will take the case from here on.
The council seeks permission to move forward with the next issue. So now I'm going to prove that the respondent are not guilty of possessing and using genuine forged or counterfeit currency notes or banknotes for an unlawful act. It is important to note that there is no proof that the activities described in the statement fulfills the requirements set out in the section 489B and 489C of the IPC 1860. The essential ingredients of the said offense being that the person who receives the note has reason to believe that the said notes are forged or counterfeited. The burden of proof beyond all reasonable doubt that the accused had knowledge or reason to believe that the currency notes which were put to use or possessed by him were counterfeit or fake notes is not on the prosecution. When mens rea is absent, Mere use of any forged or counterfeit currency notes or banknotes cannot be attract the provision of Section 489B. The accused in this case were completely unaware that they were handling counterfeit money or banknotes. In the case of Sanskriti Jayantilal versus State of Maharashtra, it was stated that mere possession of counterfeit notes is not punishable under law, and it must be established by prosecution that possession was with knowledge and that the said currency notes are fake or counterfeited. In such circumstances, petitioner cannot be tried for an offence under Section 489B in absence of any material to attribute such knowledge on their part. So now I am going to prove that Section 489B has not been an offence under Section 489B has not been established. There is no absolute evidence or corroborative statement establishing that the use of forged or counterfeit money or banknotes as a result, based on only on the prosecution statement, the court cannot find an offence under Section 489B of IPC. The following essential ingredients are required to make an offence under Section 489B. The note in question is a currency note or a banknote. It was forged or counterfeited. The accused sold to, bought from, or received it from any other person. The accused knew or had a reason to believe it was forged or counterfeited. In the case of Umashankar versus State of Chhattisgarh, it was held that possessing or intending to use fake or counterfeit money notes or banknotes is insufficient to prove a case under Section 489B in the absence of mens rea. And in this case, Kalumama briefed them on a project in which they need to carry a suitcase from one area to another and turned it off to Peter. As a consequence, Samir and Monu were completely unaware that they were carrying counterfeit cash in their luggage. Samir and Monu were detained as the train arrived at the Old Delhi railway station. They did not do anything illegal, but the accused were knocked out after seeing a number of officers. As a result, the court cannot find an offence under Section 489B of IPC based only on the prosecution statement. Now I am going to prove that an offence under Section 489C has not been established. There is no absolute evidence or corroborative statements establishing possession of forged or counterfeit money or banknotes. This cause makes it illegal to know or have reason to believe that the cash notes or banknotes are fake or counterfeited. To establish an offence under Section 489C, the following fundamental elements must be present. The note in question is a currency note or banknote. The note was forged or counterfeited. The accused had possession of the currency note or banknote. The accused planned to use the currency note or banknote as genuine. The accused were aware of or had cause to suspect that the note was fabricated. Only the prosecution statement cannot be used to establish an offence under Section 489C of IPC. Without the aforementioned mens rea, selling, buying, receiving from another person or otherwise trafficking is in or using as genuine forged or counterfeit money notes or banknotes does not constitute a crime. The respondent in this case had no idea that they were dealing with counterfeit money or banknotes. There is no evidence from any witness that the counterfeit notes were of such kind of description that a casual examination would convince someone of average intelligence that they were fake. So, moving towards the next issue. So, here the respondent are not liable under Section 201 of IPC. This section addresses situation in which someone destroys evidence in order to avoid facing legal consequences. However, there is no evidence to substantiate the crime and there is no evidence to substantiate the claim. This section addresses the two action of evidence disappearance and false information, focusing on the issue of evidence disappearance, which may include the following key elements. Evidence must be removed from the scene of the crime, which implies the crime must have occurred. The accused must be aware of the crime and the accused must have firm purpose to remove evidence in order to protect the offender from legal consequences. The prosecution did not provide evidence that the defendant had misplayed the evidence in this case. Although Peter was found absconding, this does not imply that evidence from the crime has disappeared. There is no proper evidence that the accused knew about the crime. Nevertheless, there was no intention of erasing evidence in order to protect the accused. As a result, it is humbly submitted that the prosecution basic statements are untrue and overstated. It was even the prosecution obligation to safeguard the evidence. Furthermore, there is insufficient evidence to prove my client guilty. Furthermore, owing to a lack of proof, the prosecution is fabricating stories in order to convict an innocent individual and avoid their responsibilities. The accused is not liable under Section 201 of IPC. So now I'm going to prove that the respondent are not liable and did not commit any terrorist attack since Section 15 of UAPA Act defines a terrorist act as whoever does any act with the intent to threaten the unity, integrity, security or sovereignty of India or with intent to strike terror or likely to strike terror in the people of any section of which the people in India or any foreign country. The phrase of terrorist act has been defined in a very wide and detailed manner within section 15 itself. In our opinion, the court must be careful in employing the definitional word and phrases used in section 15 in their absolute literal sense, or use them lightly in a manner that would trivialize the extremely heinous offense of terrorist act. Without understanding how terrorist is defined, different even from conventional heinous crime. Terrorist acts are meant to destabilize the nation by challenging its sovereignty and integrity, to raise the constitutional principle that we hold dear, to create a cycle of fear and anarchism among common people. My client are just normal people who are acting under their ambits if rights as provided by the Constitution. They did not want to attack the government. They are just dissatisfied with the government who want to divide youth of various caste and religion, and they are showing out merely sensitizing people about it and holding training camps across the country. Section 16 seeks to punish the same terrorist act as established in Section 15. As we already submitted that there was neither a terrorist act nor there was an attempt to do so. Section 17 seeks to punish people for raising funds for terrorist activity. But as of yet, there was no solid evidence established which proves the same. They are only confessions which my clients made allegedly to the police officer, but there is no solid evidence to prove the same. So we are going to deny it. Section 86 punish any person who requires or caused to be requited by any person for commission of a terrorist act. But there is no way to prove that. Our clients was merely a member of a small union who wanted to work for the betterment of society. They even held skill development training camps in various parts of the country to help other people. There is no solid evidence to prove that they were funding money for any terrorist act. So none of my client even recruited any person for any terrorist activities. And for the same reason, my clients are free of charge of Section 20, which seeks to punish terrorist gangs or organization, because they were not a part of a terrorist organization but an union. So that concludes my submission for the day. I pleaded before this court to acquit the accused for criminal conspiracy under Section 120B of IPC 1860, acquit the accused for using and possessing counterfeit currency notes under Section 489B and 489C of IPC, acquit the accused for attempt and facilitate to wage war against government of India under Section 121 of IPC, and acquit the accused as they're guilty for a charge of terrorist act under Section 16, 17, 18, and 20 of UAPA 1967, and pass any other order that this honorable court may deem fit in the interest of justice and equity and good conscience. For this act of kindness, the respondent shall duty bound forever pray.
If the judges have any questions to ask to the participants.
Often it says that the share of the circumstantial evidence is given.
Pardon, sir. Can you please repeat it?
Circumstantial evidence की चेन कैसे ब्रेक हुई ये एक्सप्लेन कर दीजिए.
Sorry, sir, you are not clearly audible to me.
If my brother permits, may I repeat the question, because I had a similar question in my head. Look, you are constantly demolishing the prosecution story. My learned brother wants to know that the entire prosecution, according to you, is based on circumstantial evidence. Now, where are the breaks? How does the story of prosecution based on circumstantial evidence, where all do you see the breaks that you would like us to go through? Am I correct, brother? You have to break. Where is the break in the circumstantial evidence theory? What breaks do you see? Can you highlight some breaks? It is always very difficult to defend, especially when your client is accused of such serious offenses. And so, brother, do you have any other question? Can we give a closing remark just as a...
Okay.
Court Master, is it over, or can we give a closing remark or
My lord,
something?
they had reserved 5 minutes. Both the teams
All
had
right.
reserved 5 minutes for rebuttal.
Okay, okay. So would any others, can we give opportunity to other speakers from the group? Because my learned friend my brother had a very valid question, which I think needs to be responded if the speaker one from the defense would like to answer that question.
Speaker Varun, would you like to answer the question?
Anyone?
Yes, Your
My
Lordship. So one of the
learned
crimes in
brother
the
has put the speakers truly on defense.
Okay, let us then
Ma'am, if
move
you
ahead.
For the rebuttal prosecution, we can give 5 minutes to the prosecution for rebuttal now.
Yes.
may we have your permission, Your Honors, for the
Yes.
buttons?
Yes.
So, Your Honors, first, there has been nothing but mere denial of provision, and that is not justification from this defense. Defense has accused the police of putting unnecessary sanctions. Those are some serious allegations, Your Honors. Considering the onus to prove their innocence is on the defense, they haven't been able to really justify the provisions laid on them. Another thing, Your Honor, is they've questioned meeting of mind common objective in regard to criminal conspiracy, in regard to the FICNs which were recovered from them. Your Honor, albeit mere possession is not an offense. But here, Supreme Court has ruled out in the earlier judgments that denial of the fact that the accused had no knowledge of currency being fake is no justification altogether. As there is no defense to the violation of law, again the maxim speaks for itself: ignorantia facti excused, ignorantia juris non excused. That is, and carrying FICN, possessing FICN, including the use as an offense against the stability of economy, thus the offense is not justifiable by the defense. Statements of defense have been found contradictory considering their statement from page number 12, penultimate lines, about that the respondents disclosed all the information about the planning and had nothing to hide. If we have to admit all the confessions made by them and there's nothing to hide and everything is true, the case itself is prima facie found them guilty of all the allegations made by accused thereof. If there's nothing to hide and all the information provided to them was without any caution by police or NIA, thus I think the court understands that all the confessions would thus be held admissible, and where they've admitted that there was an attack being planned and they were receiving funds thereof related to the same. Further, Your Honors, I'd like to say about the rioting, as per their fundamental rights, what the defense spoke, rioting is against the public tranquility, whereas joining an insurrection against the government of India is also forming part of war. And the boundaries by Article 19 of IC should not, Indian Constitution that is, should not be violated and should be counted reasonable in the present case. That's it, Your Honor. Thank you.
So we reserve
Defense,
judgment.
my lord, defense counsel, do you want to make your submissions of rebuttal?
So we have one question. So, so our question is that to our opponent counsel is that they mention that even if mens rea is not present, we can charge a person under section 489C of IPC. But as per we know that mens rea is an essential element to constitute an offense under section 489B. And even directly or indirectly, they said that mens rea wasn't present. So how can they charge an innocent person under section 489C of IPC?
Your Honor, may I answer? So, defendant's counsel, I like for you to notice what the speaker one, my co-counsel, said in the very first statement she made, that mens rea was always present. And by the statements, when the sanctions were imposed by the government, when they were receiving funds from the war country, from the countries where at war at, that is Pakistan and Bangladesh, and they still revoked it. and still stood still and still stood on the grounds that they wanted to revoke and they wanted to give their rebuttals and show their disregard against the government policies. And the FICNs were thereof found without any legal justification, with valid justification. And they confessed, which was admissible, and even Kalumama accepted that they were asked to deliver those bags to Delhi and further to Pulwama and Jammu and Kashmir thereof, shows their legal mind, and your mens rea thus would have been proven, if that justifies you.
Any other questions from the defense side? My lord, we are over with the arguments and all the submissions. So with
Can
this,
we have feedback from the judges, if you don't mind?
My learned brother, Deepak ji, would you like to go ahead?
आप सभी ने प्रोसिक्यूशन ने तो अपना वर्जन बहुत अच्छी तरह से रखा और डिफेंस ने भी अपने वर्जन को बहुत अच्छी तरह से रखा, बट टेक्निक तो आप लोग काफ़ी अच्छा बोलते हैं, ठीक है, कॉन्फिडेंट हैं, लॉ पॉइंट्स थी, लीगली भी आपने अच्छा उसको एक्सप्लेन किया और इंटरप्रेट किया चीज़ों को, बट जब हम किसी केस को पुटअप करते हैं प्रोसिक्यूशन में, अभी आपने कहा कि मेंसरिया जो है, मेंसरिया इसलिए है क्योंकि जो रिलीज कंट्रीज हैं वहाँ से हमने फंड रेज किया, उन्होंने फंड रेज किया, ठीक है, गवर्नमेंट पॉलिसीज के अगेंस्ट है, गवर्नमेंट पॉलिसीज के अगेंस्ट होना कभी भी यूएपीए को अटैक नहीं करेगा। मैं हो सकता है गवर्नमेंट पॉलिसी या गवर्नमेंट की कुछ पॉलिसीज के अगेंस्ट हूँ, इसका मतलब ये नहीं है कि मैं टेररिस्ट हूँ, ठीक है। अब आपके बाद डिफेंस की, डिफेंस चेन ऑफ सर्कमस्टांसेस जहाँ पर थी उसको ब्रेक कहाँ पर हुई उसको एक्सप्लेन नहीं कर पाया, ठीक है। आगे सभी ने अपने अच्छा होगा, बेस्ट ऑफ लक फॉर योर फ्यूचर।
Ma'am.
So, because we were talking about criminal conspiracy, and one of our fundamental rules is they also serve who stand and wait. So, as a defense, as a prosecution, also, it's always remember to establish that they were all acting as a team. So even those who are standing outside the restaurant and waiting, they are also a part of the entire scheme of actually serving the food and entertaining the clients. So that's how and that is where my learned friend was constantly giving an opportunity to show that, if you could show any kind of a disruption in the chain of event. Having said that, one of the, in criminal law, what we believe is it's important the same set of facts can be put by prosecution to prosecute, and how you analyze the same set of facts to prepare your defense. That's important. So, in criminal, when you're defending or prosecuting, it's very important that you put the facts in a manner that it supports either the prosecution or the defense. It's very important. Facts are the core of conviction or for your acquittal. So that was one of the feedback that I have for both of you, both the teams actually, that try and bring for prosecution also, which evidences are you talking about? So rather than using very sweeping words like all the evidences support, all the technical, this data is supporting, please put your finger A, B, C, D. These are 5 evidences which are in my favor. This is how I connect the story and it's a complete foolproof case. That's it. You win the case. You can actually win the case in 5 minutes if you can put that down. Similarly, so the law only comes. So one of the things that we learned from our senior, they would say that know the facts of your case because the judges know the law. You have to assist them in understanding how in this fact that particular law will not apply. So I have gone through the memorials also, and I realized that there is a lot of emphasis on expanding, which is good. Like understand this, you are all law students, and understanding, trying to stretch your understanding in terms of your ambit of legal knowledge is it's excellent. But eventually, at the when you are in ground zero, it's your facts and facts alone which will take you or will make you sink. So all the best to both the teams. You're all winners because you have participated in one of the national moot courts organized by this organization, Adhivakta Parishad, at a national level, the grand scale. You all have reached this level. You have already gone through so much of scrutiny of very learned counsels who are practicing all over India. And I wish you all the best. Thank you.
We are very grateful
And
for
thank
this
you, Court
opportunity.
Master Sir. Thank you.
Thank you, everyone.
Thank
Thank you,
you.
judges.
Thank
It
you
was a
for
pleasure to be a part of this session. I request the judges to email us the score sheet after signing the score sheet. The judges may send it us on email, or the judges may also even send us on WhatsApp.
We'll do that. We'll do that.
We are
Thank you.
closing the session. Thank you
thank
so much,
thank
everyone.
you for
Thank you.